Thank you.
Thank you.
All right, so this is the bond forfeiture docket, Nisi case number 24 DCCV 1018. And I guess these are both kind of similar issues with regard to the same bonding company, correct?
Bond forfeitures, repeat DWI offenders, probation warnings, plea deals, lawyer money problems. This docket is everything. What starts as a technical argument between a bonding company and the court quickly turns into a hard look at accountability. Who's responsible when a defendant violates bond conditions? The court, the bondsman, or the defendant? And by the time we get to sentencing, we're looking at a .229 BAC, weekend jail time, mandatory treatment, and a judge who makes it very clear, violate probation, and you're staring at 10 years. This isn't just paperwork court. This is where consequences get real, and where excuses run out fast.
Correct.
I think they're identical.
And then 24 DCCV 1321. Mr. Kelly or Mr. Romano, what's...
On Mr. Celestine, and again, I think the issues are the same here, is that the defendants in each of these cases, in Mr. Celestine's case, he was ordered, I think, by the court to get a drug patch on one setting, given 24 or 48 hours, go get a drug patch, come back, or give us notice that you've done so, and for whatever reason didn't. So my interpretation of that is a bond that should have been revoked by the court, not forfeited, or left Mr. Romano and his company responsible. That was an issue between Mr. Celestine and the court. I think the issue is the same.
Well, I mean, if he...
You ordered it in court one day. He apparently showed up to court, and we weren't notified at the jail that he had to have one. So his first setting, you showed up and said you need to have a drug patch within 24 hours. It didn't get done. We didn't know it didn't get done, and so the next court date we moved the hearing up, and he didn't show up to court. So that's kind of the issues on both of these.
But if I had, did you not know about the court dates? I mean, regardless of, if there's a bond violation, a lot of times what I'll do is, if it comes to my attention through, Ms. Werner will get the emails from whoever it is that they're supposed to have a GPS or a drug patch. And then if I get some type of referral back from them that says either they're not wearing it, or they didn't get it, or they tested positive, sometimes if it's a positive, I'll at that point just raise the bond and do it at large without proper bond. If sometimes though, I'll, instead of waiting till the next court date for these violations, I'll move it up a week or two. So I guess if I moved it up, which is what it sounds like, for a bond hearing, just a review to see what's going on, are you saying you didn't know about that date?
No, we knew about the court date. What I'm stating here is when we did the bond, the drug patch was not a part of the bond that we did with the client. That was a condition between the court and Mr. Celestine on this actual situation.
Right.
And basically, what I'm stating here is some of these bond conditions are setting us up for failure. I mean, like this guy, you gave him 24 hours to get in and get the drug patch put on. Okay. But he knows he didn't get it put on 24 hours later like he was supposed to. So at that point, the bond should have been either at large without proper bond. I mean, even if we want to do judgment nieces, they can be defendant onlys, because we're the ones getting punished here for bond conditions that when we post these bonds at the jail, we don't have much to know about. I mean, the next guy violated 18 times bond conditions that we didn't know about until the day of the hearing that he forfeited on.
Young man, respond.
Yeah.
There's a couple of things. Number one, if the bondsmen want to know what conditions, what changes are being made here in the courtroom, they should attend the hearings. It's not appropriate for the court to.
Well, let me stop y'all. I think the conversation that we need to have is probably something that we need to have maybe at a bail bond board meeting, where we can address if and how those conditions can be relayed when we do them here in court to you guys. But the thing is that's every court does it differently.
Yes, ma'am.
But the court date and the bond forfeiture, it is what it is. I mean, they didn't show up. You're not saying you didn't know about the court date. And so I think regardless of why I set something, whether it was because of a bond issue, that to me, we're talking about two separate things. Somebody didn't show up for court because of a violation of a bond condition, but but they didn't show up for court. So that's a forfeiture. If I know, it's just different on how, it depends on, for me, how I handle them. And we can talk about that later.
So on the next one, the state even filed a motion to increase or revoke.
Mm-hmm.
We set a hearing for that. He had violated 18 times. We didn't have any notification from the ankle monitor business. And we have no grounds to drop him when he is violating those conditions.
No, I understand that y'all might need some type of, I understand.
So I'm asking for some kind of relief because this next, I mean,
Well, I don't know that I knew someone violated 18 times.
I didn't say you
because,
did.
No, I'm just saying, I don't know that either of us
Yeah.
knew that. Because if someone's violating an ankle monitor 18 times, typically it's going to
Somebody's-
immediately be at large without proper bond, not just let's reset a hearing for a week out, because I would be concerned about that. So sometimes we may not get it from the company until they say, oh, look, there's been a whole
Yes,
lot of these. And so we don't know that either. So that's obviously something we need to take up. I guess,
John, if I might respond.
yeah.
Section 2213 does not list the court changing bond conditions as a grounds for exoneration on the bond. I mean, it's simply not there. I mean, it's, the court has to address the defendants as the defendants appear in the court. The bond conditions for the jail, right now, Mr. Romano has not told the court that they can't go over to the jail and pick up a copy of the conditions that are placed on them at that time. I don't know why they're not getting communication from the
Well, no,
ankle
he's
monitors.
getting them, they're getting them
It's fixed.
when they're initially done.
yeah, it's fixed now. That issue.
That's been, yeah, we've been working on that.
Otherwise, they
But
can
what
attend
he's
here.
not getting is their information here. And I understand that they can't also be in every court every morning. There's, I don't know how many people they have working for them, but we've got 4 or 5 courts going on. So I understand that there's an issue potentially with getting that information. I don't think it changes legally, though, the fact that there was a court date, knew about it, the defendant didn't show up for that court date. And so I don't think legally there's relief necessarily that I could give unless there's some agreement to that. I do understand where you're coming from, but I think the fact that y'all knew about the court date, there wasn't some communication issue with knowing that he had to be here, or both of them were guys, that they had to be here, and that it didn't show up. I understand what you're saying. If you knew that there were those violations ahead of time, maybe y'all would have filed an AFRS or whatever.
That's part of what my thing is. We can't. We do bail bond agreements with these people, and it spells out what grounds we have.
Right.
So these violations have to come from the court as far as the issuing of warrants, and I can't even go rearrest them. We have a investigations company, but I can only go pick up on our forfeitures. So even if we do it at large, my hands are tied on some of this. And Mr. Price just wants us to keep going after these people, and I understand that. But even on this kind of situations, I can't go after these people. I can't even issue a warrant for them. Legally, I cannot, because they could come back at us and go, well, here's what our contract says. Well, the bond conditions were not part of our bail bond agreement.
Well, what if, we need to talk about that later too. Make a note, because why can't y'all put in your bond agreement that it's any bond conditions that are there and any bond conditions that the court orders?
That would be something we have to do after the fact. So sometimes, like now, we're knowing bond conditions. This isn't an issue that's going to keep coming up because they fixed it at the jail. But this is some of the old stuff that we didn't know until we get blindsided. Like,
So were these my conditions on both of these, or were these conditions that were, because I think that is different. If these were conditions that were placed by the magistrate at the jail, or were these conditions that were placed on them here in court by me?
I'm sorry, Judge, on Mr. Celestine, I believe that was the court's
yeah, that was the court's.
on the drug patch.
Okay.
These were the court's standard conditions because they're
One's a
general violations anyway.
Mr. Ortiz, I think, is going to be yours also.
Okay, so these weren't the jail issue. Okay, all right, then it,
This exchange highlights a tension that doesn't always get talked about. Bondsmen argue that when courts modify conditions after the bond is posted, like adding a drug patch requirement, they're being held responsible for terms they didn't originally contract for. But legally, the judge is focused on one thing: appearance. Under Texas law, bond forfeiture happens when the defendant fails to appear in court. The reason for the non-appearance doesn't erase that obligation unless it fits specific statutory exceptions. And as the prosecutor points out, changing bond conditions is not listed as grounds for automatic exoneration. The judge acknowledges a communication problem, especially with multiple courts and evolving conditions, but separates that administrative issue from the legal consequence. No show equals forfeiture. So here's the question. Should bondsmen be financially liable for violations they didn't know about? Or is appearance always their responsibility, no matter what?
I'm going to grant the forfeitures in each case, and then we can discuss somehow, if I get with all the courts, though, to figure out a way to get bond conditions that are placed on them after the fact by the court, which happens all the time. And so I don't know, really, other than y'all being here, but we can try to work something out. But I don't think that's necessarily the issue's going to be getting everybody to do it the same. But we can talk about it at Bail Bond Board. All right.
Your Honor, just for clarification, I would ask that the court take judicial notice of the court's bond forfeiture docket for the cases thereon,
We'll do so.
and take judicial notice of the bond forfeiture case and the underlying criminal case in each of those,
We'll do that as well.
and enter judgment according to the court's docket.
I will do that as well.
We have final judgments prepared for that, Your Honor.
Okay, thank you.
Thank you, Your Honor.
All right, and hey, remind me, and we'll try to figure something out. All right. Good morning. How are you?
Good. It's Monday.
Yes, it is. I've been texting with her sister. Mr. Rodney Latiolis?
Yes, ma'am.
And Mr. Latiolis was previously in court, entered a plea of guilty to driving while intoxicated, third or more. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Are there any additions or corrections?
None from the defense, Your Honor.
Are you sure?
Well, he does take responsibility for it. We did review his BAC level at the time of the stop, and
So here's the thing, Mr. Latiolis, your BAC was .229. .229. What you said in here is that I'd had a drink the night before, but not that day, and that you hadn't eaten anything. So you're saying you had a drink the day before, and you were at .229 when you got this. That doesn't make any
No, ma'am.
sense.
I went and stayed at a friend of mine's house, and we stayed up, barbecued, and drank till probably 4 in the morning,
Okay,
and then went to bed.
okay, all right. Anything, Ms. Malfino, then?
No, Judge, only if the court thinks that the length of probation is appropriate, I understand. If you feel
A .229 BAC. That's nearly 3 times the legal limit. And this is DWI third or more, meaning this isn't someone's first mistake. When the judge confronts a defendant about claiming he only drank the night before, she's pointing out something important. Credibility matters. A BAC that high doesn't line up with just one drink yesterday. The sentence here is structured but serious. 10 years assessed, suspended to 5 years probation. That means the prison sentence is already set. It's hanging there. If he violates probation, the judge doesn't have to redecide punishment. It's already decided. The weekend jail time isn't symbolic either. Mandatory confinement up front reinforces accountability, while outpatient treatment through JCDI shows the court is focused on rehabilitation. But here's the bigger issue. How many chances should someone get when alcohol keeps bringing them back to court?
if you feel the need to change that.
and we are. I did speak with Mr. Nichols about the 10 days. If Mr. Latiolis could serve him on the weekends.
Are you working, Mr. Latiolis?
No, ma'am.
All right.
He has a disease that he sees doctors weekly for, and so that was the reason.
And I know Mr. Nichols did discuss his medical condition as well
And,
last week.
and the therapy,
Right, your physical therapy.
yes.
All right, so what day are your doctor's appointments and therapy on the same days each week?
No, ma'am, my therapy's daily. I have a device that's prescribed that I use 2 hours in the morning and 2 hours in the evening.
Okay, so I mean, that's something that you're gonna have to have it taken care of in jail anyway, even if it's weekends, right?
I don't know if they'll let me bring the device in.
What is your schedule? What is your weekly schedule with the doctor and the
Well,
therapy?
I'm seeing 3 different doctors. The therapy's daily, and I see one doctor once a week, one doctor bi-weekly, and then one monthly.
Give me a second. Okay. Okay, so what I'll do, you're just gonna have to get it figured out, with the jail, if they do or don't allow, that device in. If not, you'll have to work it out, where you're just without it for a couple of days. I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you, find sufficient evidence to find you guilty, and at this time, find you guilty of driving while intoxicated, third or more. Sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. I'm going to suspend that, place you on probation for 5 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. That will include 10 days mandatory upfront time. I will allow you to serve that on weekends. You will be required and ordered to report to the Jefferson County Jail to start that this Friday, June 27th at 6:00 p.m. And so you have to be there at 6 o'clock. You need to be on time. If you're late, it's a violation of your probation. If you show up under the influence, a lot of people think they're going to show up under the influence and sleep it off over the weekend. That's a violation of your probation. You'll be right back in here. And you'll do those weekends from Friday to Sunday until the 10 days are satisfied. Also, I am going to order that you enter and successfully complete the Jefferson County Drug Intervention Program. That's the JCDI program. It's an outpatient treatment program to make sure that you have all the tools necessary to stop drinking and stay on probation and not end up in prison. If you don't make it successfully through that program, you're going to end up right back in here looking at the 10 years. Do you understand?
Yes, Your Honor.
You're also ordered to have the auto ignition interlock device. Do you already have that on your vehicle?
No, ma'am.
Doesn't drive.
I'm not driving.
Okay,
My truck's not even legal. I don't have insurance on it.
so as long as you're not driving, obviously you don't have to have that, but you're not allowed to drive any vehicle. So you can't borrow a vehicle or rent a vehicle, nothing like that unless it has that device on it, okay?
Yes, ma'am.
So again, if you do everything you're supposed to while you're on probation, this is a good opportunity because for all practical purposes, your case here in court is over and you'll serve that 10-year term while you're out on probation. The other side to that, again, is if you violate any condition of probation, you'll be brought back into court and you could be facing that 10-year sentence that you agreed to. Do you understand?
I do understand.
And I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. If you'll just have a seat here in the courtroom, probation will call you up when she's ready to go over your paperwork.
Yes, ma'am.
Good luck to you, sir.
Thank you.
And then you've got Rosendo Ochoa sentencing.
Yes.
Good morning. Are you Cameron Gutierrez?
Yes, ma'am.
And Mr. Gutierrez, did you get someone hired?
No, ma'am, I got them, so list of them.
Who'd you talk to?
Walker, Hall, Crenshaw, Rennick, Bailey, James, Wilkerson, Holmes, and J.D. Hill.
You talked to all of those?
Yes, ma'am. And
Hang on a second.
2 of them I didn't talk
Listen,
to.
who'd you not talk to?
It was B. Holmes, she was on vacation when I called her, and another one I was waiting, J.D. Hill didn't call me back.
Okay, because he's a DA now.
Okay,
That's why I was asking.
yes, ma'am.
So you actually talked to the others?
Yes, ma'am, I did speak to the rest.
And so where are you on being able to get someone hired?
I don't, I'm not gonna be able to. ma'am.
Are you working?
Yes, ma'am.
Where are you working?
At all code,
And is that full-time?
full-time, yes, ma'am.
Okay, and what's your hours?
Monday through Saturday from 7 to 5,
And what's your hourly wage?
$21.
I don't know that you're gonna qualify for a court-appointed lawyer. I'll have you fill out some paperwork this morning. You need to fill it out accurately and completely. You're gonna swear under oath that it's all true and correct. So put any income, any bills, and then I'll take a look at it and see where you stand, okay? You'll step in front of the clerk. She'll give you that paperwork. Good morning.
Hey,
You're Daryl Albritton?
yes, ma'am.
And Mr. Albritton, did you get someone hired?
I'm still working on it. They kind of expensive because I had to pay for my daughter's funeral, so.
I'm sorry, I can't understand.
I said they kind of expensive, so I'm still working on it because I just paid my daughter's funeral.
Okay,
Passed my daughter,
right.
so,
And you're working still?
yeah, I work in the plant.
All right, who'd you talk to? Which
All
lawyers?
these people right here.
Just tell me which ones they are.
Walt Wonder, Corey Crenshaw, Buddy. Yeah, I talked to some more on the phone. Them the ones I met in person.
Okay. So what I'll do, and I know you went through that with your daughter, I'm gonna reset your case about 30 more days to give you some time to try to get someone.
Quick question. The attorney you gave me, he said you gotta redo all my paperwork so I could rehire him or something.
So you were appointed Mr. Lewis when you were in
Yeah.
custody, but once you bond out, I expect you to hire your own lawyer. You've got a job, so you need to try to hire your own lawyer. You're welcome to talk to Mr. Lewis about hiring him. He's still technically your court-appointed lawyer, but I expect you to try to hire someone before that next court date. If it's not gonna work out with the ones that you've already talked to, talk to at least 3 others. You can tell they all charge, and it's all very different. Bring me those names. If for some reason you don't get someone hired, let me know who else you've talked to and we'll discuss your options, okay? Thank you. If you'll step in front of the clerk. Good morning. Are you Brianna Clannon? Answer out loud so I can hear you. How old are you? You're 20. Next time wear something more appropriate to court. Okay? Do you agree that that's probably not something appropriate to wear to felony court?
Yeah.
I tested you this morning. You gonna have anything in your system? Have a seat in the jury box. We're gonna get you drug tested. Good morning. Are you Gerald Jackson? Mr. Jackson, were you able to get someone hired?
I was hiring Nolan Bronx, but he told me that he's no longer gonna do Beaumont.
Oh,
So
okay.
he referred me to Dustin Galmore,
Uh-huh.
and I was gonna hire him.
Okay.
The process, but he charged me $8,500, so I gotta get $4,200 to be able to get it.
Right.
And I'm trying to get to the amount.
That point, okay. All right, so your case is getting old, and you've got 3 of them, so we've got to try to get something done. See if you can get him hired before the next court date. If you can, great, bring him the reset notice. If not, talk to some others. See if there's someone else you can afford and hire. If you can't, then we'll discuss your options at the next court date.
Yes, ma'am.
All right, step in front of the clerk. Good morning, ma'am. You're Shay Morgan?
Yes, ma'am.
Did you get someone hired, Miss Morgan?
I actually had the funds to hire somebody this morning. I got a call from an investigator on Friday, and my car was taken. So the investigator told me that it was not a real Geico agent, and he's taking the money from my account. So they,
Miss Morgan, you've had the most,
a mess,
I'm sorry?
a mess.
Well, it's a mess, but there's just a lot of issues that you're blaming on other people, and you've been coming here now for a long time.
No, I mean, I'm coming to ask to get a court appointed. I mean, or I couldn't hire an attorney because I felt like my income wouldn't allow me to get an.
Are you working now? So what makes you think that if you're working, you would get a court-appointed attorney?
I'm just gonna have to resave the money. The whole reason I denied a court-appointed attorney was because I knew that I wouldn't qualify. So, basically my attorney they told me it was $10,000, so I had the money. And, I mean, I can show where they took it out of my account.
Where are you working?
Lake Pool and Water,
I'm sorry?
Lake Pool and Water.
And what,
Eastland, Texas.
okay. And what are your hours?
I'm a finance manager, so it's just one of the places I work on.
I can't understand you.
9 to 7 usually. The dealership closes at 7.
Okay. And what, do you make an hourly rate or a salary?
No, my income, I started on the 8th and it was $8,300 a month.
Okay. You need to get a lawyer hired, and you need to try to get one hired before the next court date. If you're making $8,300 a month, you are not going to qualify. You've been coming for some time. This is your last reset. You need to find a way to get someone hired. No more excuses.
Okay.
Step in front of the clerk. She'll give you a reset notice. Good morning, sir. You're Lance Charbino?
Yes, ma'am.
And were you able to get someone hired, Mr. Charbino?
I had called to
10 or 11 different ones, but I got the law office of James R. Nathan, PC, and then Roebuck, Thomas, and Adams, DLLC. William Marcus Wilkerson's attorney at law. I just started working last week,
Okay,
and I am going to make a couple more calls to them if I'm able to.
Okay.
Be able to get me one night.
okay, sounds good. So thank you for doing what I asked you to do. I'll give you another 30-day reset. If you can try to get one of them or someone else hired, great, bring the reset notice to them. If not, just call some others, like you said, bring me those names, so know you're still trying, and then we'll discuss your options. All right, step in front of the clerk. Yes, sir. Ciandre Stevens, good morning, ma'am. Did I say your first name?
No, ma'am, it's C. Andrea.
C. Andrea, sorry about that. And Ms. Stevens, were you able to get someone hired?
I actually talked to Mr. Ryan Gertz, and he gave me his pay rate, and I'm about 2 checks away from getting him his down payment.
Okay,
But I have a question for you.
mm-hmm,
Instead of paying a down payment for what he wants to start with, I have a lawyer who's trying to do the case for me for the whole amount that I can start off with Mr. Gertz. And I was wondering, just can I go ahead and use the lawyer I told you about the first time I used?
you can use whoever you want to.
You told me I had to get some more money.
No, I never said that. I never would have said that. So what I might have said was that and I don't remember our conversation because I see a bunch of people every week. But I can assure you I've never told one, because it would be illegal for me to tell someone they have to hire someone from a certain place. Now, hiring someone locally may be less expensive than someone coming in from Houston. Sometimes the people from Houston have issues getting here on time and things like that. I don't care who you hire. So absolutely, if there's someone that you want to hire that's more reasonably priced, as long as they're willing to come here for your court dates, that's fine with me, okay? So I'm sorry for the misunderstanding. I'll give you about 30 days to get whoever you want hired, and then bring the reset notice to whoever you hire, and they'll tell you what to do, okay? All right, step in front of the clerk. Rowan, okay. Good morning, you're Louis Contreras?
Yes, ma'am.
And Mr. Contreras, did you get someone hired?
Right now, at the moment, man, I'm struggling. My truck was missing for 2 months. It got stolen right here in Beaumont. Then we found the truck last week on Thursday, right here in City Spring.
Mm-hmm.
And they took everything out from the truck, my radio.
Are you working?
Yes, I'm working right now, but I'm struggling with the car right now. And I got 3 kids, and it's hard for me right now.
Did you talk to some
Yes,
lawyers?
I talked to Rojas, but Rojas said that, oh man, I'm gonna try to see if I can work it out with you. And so I'm trying to see if I can get somebody else, and it's hard.
Yeah,
Right
I
now,
understand. Did you?
Right now, my wife she's facing charges to the guy. My truck was stolen so for 2 months, so I was no ride for 2 months.
Okay. I'm gonna have you fill out some paperwork this morning, Mr. Contreras, to see if you qualify for a court-appointed lawyer. You need to fill it out accurately and completely, because you're gonna swear under oath that it's all true and correct. So put whatever your income is, whatever your bills are, and then I'll take a look at it. Step in front of the clerk, she'll give you that paperwork. Good morning. You're Christian Ainsworth? And Mr. Ainsworth, did you get someone hired? Did you talk to some lawyers?
This past month has been very stressful. Like, next week, my mom just passed away yesterday.
I'm very sorry. And I appreciate you being here, even though that happened yesterday. So I will reset your case about 30 days. You can get past that. Call some lawyers in the meantime, okay? Once you get past funeral and whatever you're going through, talk to them, see if you can afford someone, bring me those names, and we'll discuss your options when you come back. Step in front of the clerk. Deshandra Joseph. Good morning, ma'am. You're Deshandra Joseph. Did you get someone hired?
The last time I was here, I spoke to Deferred, and we were having some kind of release from the IRS for releasing my taxes. So you gave me a couple more days. They still haven't released him. I reached back out to him to see if I could get him some kind of payment plan. He said that he doesn't do that. He needed $5,000 upfront, and I told him, because I'm a single parent, that I didn't have that. So I was trying to find people that could do down, like, payment schedules, and I just couldn't find anyone.
Who else did you talk to?
I talked to Brittany Holmes, and I talked to Prince.
Okay. And are you working?
Yes, ma'am. I work at a daycare.
Okay. Full-time?
Yes, ma'am.
What's your hourly rate?
$2 an hour.
Okay, I'm gonna have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. You need to fill it out accurately and completely because you're going to swear under oath that it's all true and correct, and then I'll take a look at it. If you'll step over here in front of the clerk, she'll give you that paperwork. And then don't forget to grab your stuff when you walk back. Ronald Souls, good sir, you Ronald Souls?
Yes, ma'am.
And Mr. Souls, did you get someone hired?
I was told that I had my lawyer was supposed to be up here, but I'm going through like so much right now. My auntie passed, and right after she passed, my father passed. I had called the courthouse.
When did that happen?
My auntie passed in May. My dad passed like at the end of May.
Okay,
I was trying to get his obituary to bring it up here.
okay.
I'm
Are you
kinda like,
working?
I got laid off due to happening where my auntie, she lived in Atlanta, so I had to drive my mom to Atlanta. Once I came back from Atlanta, and my father passed, then I had to attend to his funeral, and I was laid off my job. I was working at Deferred.
Okay. Have you tried since then, now that all that's passed, have you tried getting another job?
I'm in the process of it, but I'm trying to get a lawyer on this case right here, and I was told that I had a lawyer.
So when you're in custody, you're appointed a lawyer automatically. And that was Mr. Rojas.
Yes, ma'am.
But hold on, so now that you've bonded out though, I expect you to hire your own attorney. We talked about that when you were here last time.
Yes, ma'am.
And so understand you've gone through some stuff. I'm gonna reset your case for 30 days for you to try to get a job first. And I want you to talk to at least 3 lawyers to find out how much they charge, what their payment plans are, see if you can afford someone once you start working. You need to bring me proof of, if you've gotten a job, I want you to bring me some kind of proof that you've gotten a job, a pay stub or something from an employer. If not, I want you to bring me proof that you're applying to jobs every single week.
Yes, ma'am.
Okay? And then we'll discuss what your options are.
Yes, ma'am.
All right, step in front of the clerk. Brandon Broussard, good morning, you're Brandon Broussard. And Mr. Broussard, did you get a lawyer hired?
Yeah, I got Justin, but I paid him like on Friday. I just need in his office on tonight.
Who?
Sorry.
Okay, so you paid on Friday?
Yeah, but I haven't got a chance to go back to office to I guess to show the proof of representing. I'm not on the payment.
Dustin. Is he on our docket today? So you actually went to his office and paid him money?
No, I did online, but I text Justin phone. He said give him $2,000 or whatever, and then I covered it, and then like.
Okay.
His office opened at 9. I had to be there.
Okay, so I'm just going to reset your case a couple of weeks. As long as you get all that taken care of, that date will probably change. He'll send us the appropriate paperwork and that'll probably have a different date. If something happens though, and he doesn't tell you about a new court date or your bondsman, make sure you come back in 2 weeks, okay? Keep that and go do what you're supposed to do with Mr. Galmore. If you'll step in front of the clerk and sign a reset, please, sir. Thank you. David Lewis. Good morning, you're David Lewis?
Yes, ma'am.
And Mr. Lewis, did you get someone hired?
Need a court-appointed
Who'd you talk to?
the same ones.
Okay. What'd you bring with you?
Open it up.
All right, I'm going to find that you qualify for a court-appointed lawyer. Are you ready for him, or do you have him sit down? If you'll have a seat right over here in the courtroom, pay attention. The clerk's going to call you up and let you know who your lawyer is going to be. Good morning, sir. You're Roderick Anders. Mr. Anders, it's very important that you get here on time, okay? I'm going to recall the bond forfeiture, and then give me a second to pull your case up here. This is your initial appearance in cause number 250388. You're charged with aggravated assault with a deadly weapon, and that's from January 26th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? All right, give me just a second to review something.
David Lewis. Mr. Lewis. Alan.
As a condition of your bond, what were any orders with regard to contact with Ms. Stevens or anything like that? I'm sorry? You have not? And that's understand that's a condition of your bond that you cannot. Were you required to wear any type of GPS monitoring device? And do you have that on? Okay, perfect. So what I'm going to do, Mr. Anders, is reset your case for about 30 days to give you some time to try to hire someone. If you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer. They'll tell you what to do. If you're unable to hire someone before that next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to, and we'll discuss what your options are. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would go back to jail. Do you understand? All right. If you'll step in front of the clerk, she'll give you your reset notice. Good morning. Good morning. Good morning, Mr. Franklin.
Good morning, Judge.
Morning, Mr. Coleman. And, sir, you are Ray No?
Yes, ma'am.
And Mr. No is charged with intoxication manslaughter with a vehicle, and as well as driving while intoxicated with a child under 15. And what is the announcement?
Judge, we are not ready. I believe the state had filed a motion for safe P records, and I don't think we've seen those. In April, the court ruled on it.
Yeah, just a moment. I think
Sure.
it sounds vague. I did, I saw some
Cameron Gutierrez.
safety.
Oh, I see that, yeah.
Yeah, and, let's see, I believe the court signed the order, but,
I did, yeah.
Yes.
oh, and Judge, I did get a response. I need to go back through my file, I don't want to misspeak, but I did get a response. I don't know that those records, after so long, were maintained. It's what my memory is.
Okay, so why don't I just do about 30 days, and then Mr. Coleman, you can check on that, let Mr. Franklin know any information that you, hey, y'all, any information that you've received, sorry, lost my train of thought. Get together, see if we can get an announcement the next court date. Thank you.
Thank you.
Good morning, sir. Are you Jeremiah Davis? And this is 250066, and Mr. Davis is charged with assault on a peace officer. And what is the announcement?
Your Honor, we're asking for a little more time. We have an offer on the case, and he wants to bring me some discovery that he thinks would help the prosecution.
Okay.
Make a different evaluation. And so I told him he needs to call me this week and make an appointment. He's called me before, but I think he's just been able to get this
Okay.
information.
Mr. Smith, any issue?
No.
All right, so Mr. Davis, I'll reset your case about 30 days. Make sure you get that done early on. Don't wait till the last minute before court, so Mr. Parker can get what you have. He can get it to Mr. Smith, and then we can see where we get the next court date. All right, you're free to go, sir. And then you've got Aaron Shetley. Good morning. Are you Aaron Shetley? Mr. Shetley, in cause number 240776, you're charged with a third-degree felony offense of assault family violence by impeding breath or circulation from October 22nd of 2022. And what that means is that if you go to trial and you're found guilty, the range of punishment would be a minimum 2 years up to 10 years in prison. Do you understand? And I have here on the tablet a plea bargain rejection that you've signed with Mr. Parker. This shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, for a 2-year deferred probation. You have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are and what your options are. And do you understand all of that? And do you want to reject that offer and have your case set for trial? All right, and Mr. Parker, you're hired, correct?
Yes, ma'am.
All right, Mr. Parker, we'll begin preparation for trial, and we'll get it set on the next available trial docket.
One thing, Judge, just, I think I have all the discovery that I need to confirm. In the discovery, it references a flash drive that was provided to the Groves Police Department. And I don't know if that's some of the discovery I have, or if there's actual flash drive that I need to get a hold of. And
Okay,
one other thing is the photos, if I can get, I can get it. Yeah, because the computer doesn't, doesn't show.
Okay, perfect. All right, thank you. Stay in touch with Mr. Parker. He'll tell you when you need to be back.
Yes.
See, Mr. Wilkerson, you have Charles Young. Good morning, sir. You're Charles Young. And this is 250102, and you're charged with burglary of a habitation. And Mr. Wilkerson, what is the announcement?
Judge, we're going to ask, I'd like to request one more announcement setting. Still working on some information, and there's some additional information also that I need from the DA's office.
Okay.
Thank you.
Has there been any issue with regard to bond conditions, Ms. Malfino?
No, Your Honor.
Well, if you recall, there was a hearing.
Yeah, that's what it
with regard
meant.
to that matter. I'm still trying to get the evidence behind that hearing. So, in terms of what was alleged, like pictures, screenshots, messages, anything related to.
Uploaded all that to Discovery last week.
Okay, all right, sounds like it's all been
And a lot
uploaded.
of that, just so the court is aware, has come from the complainant calling the front desk, making reports for NAG, who then reports it to me. I just filed that motion, not to be punitive against the defendant, just to make sure the court was aware so that there could be a no contact for both of the parties either way. And everything that I have to discuss.
Perfect. All right, so Mr. Young, I'm going to reset your case about 30 days. Make sure you stay in touch with Mr. Wilkerson so we can try to get an announcement at the next court date. All right, thank you, Mr. Wilkerson.
Y'all have a good day.
Thank you, you too. Let's see, is there a Mr. Ballas? Good morning, sir. Are you Shahram Omid?
Yes.
And this is 241684. Mr. Omid is charged with solicitation of prostitution, and it looks like there was an application for pretrial diversion.
Yes, Your Honor. We've
What's the
submitted that.
Uh-huh.
We haven't got a return, Your
Okay.
Honor, but we are willing to set this case for plea in the event it doesn't come back favorable to my client.
Okay, so what I'll do is one more reset. Mr. Smith, would you please get with, I guess, Mr. Canal or whoever is doing those up there, and if so, we can get an answer before that next court date.
Yes, ma'am.
That way you can get an answer. Either way, it'll get taken care of either
Yes,
with the
sir.
pretrial or with the plea on that next court
Thank
date.
you.
Thank you, sir. Stay in touch with your attorney. He'll let you know when you need to be back. And if it does get accepted, there will obviously be some other things where you'll need to go sign contracts and things like that. So if he gets accepted and the contract signing is after our next court date, y'all let me know. I'm not gonna make you come, you don't have to come here.
Okay.
So we can reset it till after that to make sure all that gets taken place and
Yes, sir.
taken care of, okay?
Okay.
So just keep us, we'll set it for 30 days, but let me know where things
Make
stand.
notes. Okay.
Thank you.
Thank you.
All right, you're free to go, sir. As long, you can email it to one of the clerks this afternoon. Well, did you look at it through the portal? It's on there.
I just don't have it in the file, I don't know how to get it, Philip said he was gonna get it, somebody's gonna bring it down. I'll get somebody to do it for me.
All right. As long as just get that to us by the end of the day. Thanks. All right, and sir, are you Celine Reinhardt? And will your client waive the formal reading of the indictment?
She will.
See, give me just a second. Ms. Reinhardt, you're charged with the second-degree felony offense of assault on a peace officer from December 22nd of 2024. And how do you plead to that charge? Oh, I'm sorry. Yeah, I see now. Hold on. Y'all are going on a lesser included, Class A.
Position rich.
Okay. Give me a second. All right, so in 250089, the state has elected to proceed on the lesser included offense of a Class A misdemeanor resisting arrest from December 22nd of 2024. And how do you plead to that charge? And are you pleading guilty freely and voluntarily? And because you did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Shalander? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 1-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? And are you a U.S. citizen? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Reinhardt is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 1 year. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do all of that, then this is a great opportunity because you don't have a conviction on your record. And at the end of the probation, if you're successful, the case will be dismissed and you'll never have this conviction. The other side of that, though, is if you violate any condition of your probation, you can be brought back into court and you could be found guilty of the offense and sentenced to the Jefferson County Correctional Facility for a period of up to 1 year. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom, and the probation, she's at that desk right there. She's going to call you up in a few minutes to go over your paperwork. And you're going to help get that attachment?
Sarah's going to email it to you.
Okay, thank you. All right, thank you.
Go ahead, I can do it.
That's between y'all. It's your job, but if he's going to do it, then it just has to be done today because once the case is closed out, you can't get to the portal. So that's why we need it, just so y'all make sure. So that's good. So, Ms. Clannon, you're how old? 20? All right. So what I'm going to do is reset your case for about 30 days to give you some time to try to hire a lawyer. If you get someone hired before the next court date, bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and then we'll discuss your options.
I actually hired Ray Killer. I'm just one paycheck is away from paying them off.
Gotcha, okay.
He told me to come over here today and tell you we can reset so I can have more time.
So, yeah, you'll have 30 days to see if you can get that done, and then if you get him paid off before the next court date, he should give us some documentation of that. That court date may change. Plan on being here on the court date that it says on your reset notice unless you're told otherwise, okay? All right, step in front of the clerk. If you want to make it, did you put right? Thanks.
Good morning.
Good morning, sir. You are Rosendo Ochoa?
Yes, ma'am.
And Mr. Ochoa, in cause number 240367, you were previously in court, entered a plea of guilty to evading arrest or detention with the use of a vehicle. I've received that pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your Honor.
Are there any additions or corrections?
None from the defense.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 5 years. You're ordered to pay a $300 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity. You're only 21, right? And it looks like this is your only criminal hit. You've never been in trouble before. And so at the end of this probation, if you have been successful, the case will actually be dismissed and you will never be a convicted felon, which is a very big deal.
So I don't have to worry about it getting expunged off the record, you know?
Well, you're not going to be able to get an expungement, but if you're successful, there are some other ways to get it not necessarily completely expunged, but at least kind of hidden on your record. It's called a non-disclosure, and you can talk to an attorney at the end of that probation period about that. Also, it's important that you know, I sign early terminations from probation all the time. So if you get out there and you do everything you're supposed to up front, get your community service done, get those fees paid, don't violate, don't test positive for anything, then you actually can get off your probation much earlier than that 5 years, okay? But you got to do everything right, and you got to do it right up front. If you violate any condition of probation, you can be brought back into court, found guilty of the offense, so you become a convicted felon, and you could be sentenced anywhere in the range of punishment in your case, which is up to 10 years in prison. Do you understand? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. If you'll just have a seat here in the courtroom, probation, she's going to call you when she's ready to go over your paperwork. All right, good luck to you, sir. And you have Eric Hernandez. Good morning, you're Ashley Sanders. And this is 241650. Ms. Sanders is charged with theft of service. And Mr. Kelly, what is the announcement?
Judge, if I may, the court has been very gracious and lenient with us in resetting this and trying to obtain a forensic audit. We reached out again this morning, let them know they have a date certain that we must have it by in case would likely be dismissed. They were made aware of that before court this morning. If I may just have that one final, say last reset, I won't ask for another.
Okay, all right. Any issues?
No.
I'm sure you're from that. Okay, we'll do one last final reset. Stay in touch with Mr. Kelly. He'll let you know when you need to be
And
back.
of course, if I do in fact get that, Judge, I will turn it over immediately.
Perfect. Thank you. Y'all are free to go. Mr. Lewis, you have Shy Brooks. Good morning, you're Shy Brooks. And this is 242034. Mr. Brooks is charged with evading arrest or detention with the use of a vehicle. And what is the announcement?
Judge, I've talked to Mr. Brooks. Evidently, he had my incorrect contact information. We've taken care of that this morning because there is some media that I received in relation to this case I need to go over with him.
Okay, so Mr. Brooks, I'm going to reset your case one more time. It's important that you make sure and call soon so that you can get an appointment to go see Mr. Lewis and go through all that information, okay? All right, we'll see you at the next court date. You're free to go.
Thank you.
See, Mr. Crenshaw, you have Guillermo Galvin.
Yes, sir.
Good morning, sir. Are you Guillermo Galvin? And this is 242321. Mr. Galvin's charged with driving while intoxicated, third or more. And what is the announcement?
Judge, today's docket shows the full spectrum of criminal court reality. We saw bond forfeitures granted because defendants failed to appear, even amid disputes about communication and bond conditions. We watched repeat DWI offenders receive structured probation with strict upfront jail time and treatment requirements. We saw defendants struggling to afford private attorneys, and a court carefully weighing who truly qualifies for appointed counsel. What stands out is consistency. The judge repeatedly emphasizes responsibility. Show up to court. Follow bond conditions. Hire counsel if you're financially able. Complete treatment. Don't violate probation. The message is clear. The court will work with you, but it will not chase you. From deferred probation opportunities for young defendants to stern warnings for repeat offenders, this docket reflects both second chances and serious consequences. If you found this case as shocking as we did, make sure to hit that like button. Share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
Judge, this will be a plea. We just need to get him a scram device to show the prosecution that he is correct in his statement that he is no longer drinking. And so if we could have a 60-day reset, just because we need to...
30 days. This has been since January, and we're getting close now to end of June. So we're going to do a 30-day reset, get that on as quickly as she possibly can so that she can get some of those results. Let's just see where we are at the next court date. All right? Thank you. All right, you're free to go, sir. Good morning, ma'am. Are you Alexandria Bledsoe? And Ms. Bledsoe in 250004 is charged with abandoning or endangering a child with intent to return. And what is the announcement?
Judge, we received an offer this morning. Mr. Smith was kind enough to relay the offer from Mr. Hoffpower. Ms. Bledsoe just would like to meet with me and discuss the options on the plea. We just asked for one single reset.
All right, well, any issues that you see, Mr. Smith? All right, we'll do a normal reset. Ms. Bledsoe, make sure you get with Mr. Rennick so y'all can visit about what your options are, and we'll get an announcement at the next court date. And then Patrick Gallagher.